Okay, grab some food, guys. All right, welcome everyone. Thank you all for coming. I really appreciate it. We are making a lot of changes in our court here, and I thought it was important for the bar to be aware of the changes so you don't walk in and find out any other way, right? So the first thing I want to announce that I am personally extremely excited. I know my magistrates are as well. And I want to welcome Judge Berger. Retired Judge Berger is here to, because he sits in a lot. So he was kind enough to come so he could see what we're doing. So when he's here, he'll know. Anyway, the first big announcement, and many you already knew we were working on this, is Judge Giletto and myself worked with State Representative Gail Pavliga, and as of July 1st, 2023, 99.9% positive. We're waiting for the governor's signature. I have no reason to believe that he won't sign our bill, but it has been passed through the Senate and the House and the Senate. It actually went in a very convoluted way. Judge Giletto and myself both went down and testified on 2 separate Tuesdays. House Bill 648 got voted down resoundingly, which was our bill to ask that our private custody cases be transferred to our domestic relations court. So all of the private custody, paternity, visitation, child support, all of that, we wanted to transfer it to the domestic relations court so that all of those issues were decided in one court. I don't know if any of you guys watch House of Cards, but you should, because it was a great show and it will show you what it's like in the government to a pretty real extent. So we went down on House Bill 648. When I went down Tuesday to testify, everyone was in great support until quietly another senator or another House representative of the House amended their bill onto ours, and then they made a recall vote and voted our whole thing down. So we thought we were dead in the water and weren't going to be able to transfer these cases, except prior to going to the House, we ran over to the Senate and presented our bill to the Senate. They then passed it, and then it was concurred by the House. So in a roundabout way, House Bill 648 went down in flames, and we are now Senate Bill 518, which is not even State Representative Pavliga's bill. So the good news for us is, in my opinion, is all of our private custody cases will now be determined in the domestic relations court, which leads me to the reason we wanted to do this is to essentially decrease our caseload. We do over 300 of those type of cases through this court, and it takes a significant amount of our time. And I truly believe one of the reasons I ran for this position is to be able to spend more of our time on the dependency, neglect, and abuse cases. And that's the meat of what goes on in juvenile court, in addition to delinquencies, unrulies, and the other type of cases that are typically handled by a juvenile court. So our argument to have our legislation changed in order to get rid of these cases and have them go to domestic relations is things are handled differently in juvenile court versus domestic relations. And there were a lot of times where domestic relations court would issue a CPO and we were actually hearing the case in juvenile court. We would send people to mediation and they would show up here. They were supposed to go down there. So there was just a lot of confusion with these matters, in addition to just basic things like not having the same jurists, because we're 2 separate courts making decisions about families. We actually had a case where I'm going to get the specifics wrong, but the people were married, had a child, got divorced, had another child, not married. So their one case was in domestic relations, their other case was in juvenile court. And so the bottom line is that, you know, when this was legislated originally, it was back in the day when families were different, you know, people got married. If they got pregnant, they got married. People don't do that today. The family dynamics have changed, you know. People choose not to get married and to have children together. And so we think it should all be handled in one court. And so that's what we did. It will go in effect July 1st of 2023. As I said, 99.9%, unless for some reason Governor DeWine decides to veto it, which I can't imagine. But with everything that happened over the last 6 months, it would not surprise me. So, you know, we thought our bill was a no-brainer. We had no opposition. I thank the Bar Association for supporting it. We had letters of support from the commissioners, the Bar Association, the Domestic Relations Committee of the Bar Association, and we were able to present it as a bill with zero opposition. Unfortunately, East Liverpool Municipal Court swung their bill onto there, shutting down East Liverpool Municipal Court. And everybody said, oh, no, 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 we can't do that. So our bill got voted down, but it went through the Senate, the House concurred, and it's in front of Governor DeWine. So we're very happy about that. So that's the first big change. I don't know if any of you folks here did the private custody cases, but as of July 1st, we will no longer have jurisdiction. Everything will be in front of Judge Paula Gilletto. So that's the first major thing. What we're doing is we're trying, and we want input from the bar. I am very open to hearing input from folks, and we've tried to, you know, make that known. I know people are always afraid. I'm afraid to tell the judge, son, please don't be like that, because I'd really rather hear what your opinions are. I may not agree with you. I may not even do what you want me to do, but I would like to hear the opinion and talk about it and see if we can't come to some kind of an agreement, if we can possibly do it. So we're open to hearing what you guys have to say about some of the new changes we're making. We're gonna do this, and we're gonna see how it works. And if we have some issues, we're certainly open to discussing it. We've not done this before, so we don't know how it's gonna work, and we're gonna need your input from that, because you guys are the boots on the ground. So we have already gone over this whole procedure with the Department of Job and Families, or I'm sorry, they're not department anymore, Portage County Job and Family Services, and the attorneys from the prosecutor's office. We've all sat down and gone over all of this stuff. I have myself and my magistrates, this is not something we just made up. There's been a lot of research into this. We have talked with other counties, other judges, other magistrates. We've worked closely with the Supreme Court and gotten their best practices and gotten this information from various places. So we didn't just make this up. We always used to call it a shelter care. We decided we're going to change the name to Rule 6. That's actually what it is a Rule 6 hearing. A lot of counties still call it a shelter care. There's nothing wrong with it. We just like Rule 6 better. So our first hearing on a dependency and neglect abuse case is going to be the Rule 6 hearing. How we used to do them is we scrambled when the complaint was filed, and our clerk spent hours calling lawyers trying to get people here for the old shelter care Rule 6 hearing, getting GALs, on and on and on. This is a probable cause hearing. At that hearing, we are trying to determine if the folks are eligible for an attorney and if they want an attorney. It is up to the it is up to the prosecutor's office, Job and Family Services, to put the shelter care hearing on and rise to the level of probable cause. A lot of this is going to be in the delivery of the information to these people. They will then fill out their affidavit of indigence, and we will determine whether they are eligible for counsel. Obviously, most everyone will be. We will then start calling attorneys. So at this first hearing, we're going to address these issues. We want to know what has been going on as far as what's the plan for visitation of this child that has been removed, and when the parents are going to have any contact with them. We need to find out if there's any no contact orders in place and if they need to be issued. We need to know what the placement is of this child, of this youth who's been removed from their home. We will appoint counsel if necessary, and we will always appoint a CASA or GAL. So that will be done at the Rule 6 hearing. Our next plan, is that going to work? Where's Jordan? Jordan, put your food down. It's not changing to the next screen. We're still working on all our technology. Bear with us. Yes, sir.
Appoint counsel if necessary.
So if a lot of times people will say they're going to, retain their own counsel, almost everybody is going to get appointed counsel because most of these people are not going to retain counsel. But if they certainly, it's their right to retain counsel if they wish to. So we're not going to appoint an attorney for somebody who A, does not meet the eligibility guidelines, and B, says they're hiring an attorney. So the next slide hopefully is going to tell you what we're doing next. All right, so Jordan, you might have to just sit there and change it. That's the end of the presentation. Thank you all for coming. All right, so what our plan is, and I know this is going to cause a lot of stress to people, but so at that Rule 6 hearing, we are going to be setting a pretrial 10 days out. That gives us the ability to have the time to contact attorneys, get people assigned to cases, go through all of our indigent forms and all that stuff that we need to do. At that shelter care, those folks, the parents, will be served with their court notice of the pretrial date, which will be 10 days out. That is going to be an in-person pretrial. We are hoping that the attorneys and the clients will be able to have some conversation with JFS and get all their discovery and start talking about the case and how we're going to move forward. And everybody's rights will be explained to them again at that pretrial. They will also be served with their adjudication date 40 days out. I don't think we've finalized whether we're going to serve them with a disposition date at that point, but the disposition date will be 65 days out. And we're hoping, I know JFS has said there's no way they can do this, that they'll have a case plan filed in that 10 days. I'm going to try to, the best I can, put the pressure on them to get that case plan put together. But we don't need a case plan at the pretrial. So really what we need at the pretrial is for the attorneys and the prosecutors from JFS to start discussing where we're heading with this matter. We are open to having another pretrial after that prior to the adjudication, but the parents will be served with their pretrial and their adjudication date at that Rule 6 hearing. So we will have good service and they will have all of their information of when they're supposed to be in court. The next slide, I don't even have the thing, is Alex. Alex, you guys all know Alex. You got to come up here, Alex. Sorry, she hates this. I'm sorry, but we're forcing her to do it because I think you need to be able to be heard on this. Alex, for those of you who don't know, is our court case manager. So she is responsible to essentially manage all the cases that come through this court and assist parties in doing and helping them find services and helping them resolve issues if they can possibly be resolved. So one of Alex's jobs is going to be at that Rule 6 hearing you're up.
So this is any case contact information.
Can you get Jordan? Because
So
like he
what I will
needs
be
to do
doing
this if
is
it's not going to
when
work.
parents get
If this
here,
doesn't work,
I
somebody's
will
gonna.
be getting all of their information. So mom's
Oh, it works.
information.
It works. Sorry, I just wanted to see if this worked. Sorry, go ahead.
Dad's information. When the attorneys are assigned that day, I'll put it on there as well as where they're placed. If a CASA is appointed or a GAL is appointed, I will put all that information on there as well. I will be sharing it I'll keep a copy. The guardian ad litem or CASA will get a copy. I can also send it to the attorneys as well, so they have mom and dad's correct information. So that's what my role is at the Rule 6 hearing, is to get all that contact information. JFS should actually know by the Rule 6 hearing who the ongoing worker is. So I'll have that information for the guardian ad litem's CASAs as well as the attorneys. Is they will know who that ongoing worker is the day of the Rule 6. So that's kind of my role as well, is to figure all that information out for you guys. So you guys can have it and everybody can be on that same page. So that's the paper I will be using at the Rule 6 hearing.
So anybody, if you guys need information, if you've been assigned to the case and you want more information, you can always call Alex and hopefully she can help you get the information you need. And we're hoping that this is going to streamline a little bit. The goal of what we're really doing here in the dependency and neglect abuse cases is that we're following a lot of the Supreme Court guidelines in regards to quality hearings. We need to have more quality hearings in these dependency and neglect abuse cases. And one of the things I was telling Neil before we started here is I got my first private custody case when I came, I don't know, I was on the bench not very long, and I opened up the previous files and I couldn't figure out what was going on in the case because we have all these checkbox entries. Checkbox reasonable efforts, checkbox best interest. And there was no information. Like I had no idea what the case was about and what had gone on throughout that almost 2-year period. And so we have been working on making our entries better in more paragraph formats so that we can have information within those entries after each hearing. So starting with the Rule 6, there's going to be information in that entry. It's not just going to be a checkbox of we found this, 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 and this. We're actually going to put the information in there that's going to benefit the attorneys. It's going to benefit the clients. They're going to, as we progress through the case, they're going to know what is expected of them. They're going to know where we have seen progress in their case and where we've seen concerns. And all that will be addressed in our entries. What I'm going to tell y'all is this is a bigger project than you think. And it has taken us about 6 to 8 months just to figure out where we needed to go. And now we're working on how do we make it happen? Because right now with our current caseload and with our private custody cases, our magistrates don't have the time to type all that in during the hearing. So as you've probably noticed, we're getting more and more technology in the courtrooms. We're going to start setting our court hearings right in the courtroom, and you're going to get your court notice before you walk out or as you're walking out. We're starting to hopefully have, we're going to have things available where they can do these entries. We're actually going to steal a little idea from what they do downtown is they have Darlene Pepper, who sits in a room and listens in, which I never understood how the judges got these entries out. She sits in a room and listens and types what goes on in the court, and then the judges sign off. We're setting that up here so that we can have more thorough entries for every single hearing so that it's going to benefit you guys. You can go over that stuff with your clients. They're not going to be calling you, what am I supposed to be doing? It's all going to be in that entry, and it'll give you something to go over with your client as well as them to read when they leave. So that's going to take a little bit of time. As I said, we're going to start this new procedure July 1st is our plan. But it's going to be done gradually in phases because we don't have everything set up to do all of the things we want to do. Alex is going to be a great resource for you guys. I know that JFS is sometimes, we have issues with JFS workers. We have issues with A, getting a hold of them, or B, what are our clients supposed to be doing? And you know, you get a lot of stories as an attorney. So Alex is going to be your liaison. She's going to be somebody that you can go to help you sift through some of that. And she'll help with services. If there's services that your clients may need, she can help with those resources. The first pre-trial, as I said, we're hoping to have a case plan. I'm not going to hold my breath, but we're going to try to push for the case plan. And I don't think we necessarily need a case plan at the first pre-trial because you guys haven't even gone to adjudication yet. So, you know, I'm not sure unless your clients are already voluntarily willing to do it. What you need to know is at a pre-trial, at any pretrial, that we're only going to schedule one. You can ask for another pretrial because it's going to be 10 days into the case and we're not going to have adjudication for another 40 days. If you want another pretrial, by all means, you can do so. We are willing to, if you come to an agreement, we can do that at the pretrial. You don't have to wait for the adjudication date to have your agreement put on the record and go through and be done with it, if that's what happens. I know a lot of these cases, the people do want to get their kids back. right? So they want to start working on their issues, and they want to start working on their case plan, and there's no need for us to delay them from doing that if that's what they want. So we're willing to kind of work with you guys to get this done sooner if that's something that can happen. We're certainly not pushing it. Our goal is to try to reunify these families, and also we're obviously, our goal is, the concern is child safety. So we want to make sure that when we are reunifying, that it's a safe thing to do. So at each one of these hearings, we're going to be asking a lot of questions. We're going to be putting a lot of information in there. So just as fair warning, the coming in at adjudication and stipulate out the door, that's not going to be happening. We are going to be having quality hearings. You're welcome to go to trial if that's what you want to do, but if your clients want to come to an agreement with JFS, we're going to put that agreement on the record. We need to know what some of those facts are that have occurred to get us to this point. We also need to know if they're working on the case plan. We want to know, what is their progress? How are they doing? Like, get the opportunity to tell us the good things that your clients are doing. And then we also want to know where there's areas of concern. We are also following the statute, which requires caregiver notice. Any caregiver where a child is placed is entitled to be in that hearing and be heard. And we are notifying them, and they are showing up, and they are talking. We're also obviously going to have our CASAs there when we have CASAs, and our GALs. Everyone gets the opportunity to speak in these hearings. So that's really what a quality hearing is. And I highly encourage you to go to the Supreme Court website, and they have a toolkit for quality hearings. By all means, go take a look at it so you can kind of see where we're heading. Adjudication must occur within 60 days, and disposition must occur within 90. So at the disposition, we are going to set 90-day reviews. We're not waiting for 6 months to do a review. In order to make these families accountable and try to get them to continue to work towards this, I think they need constant interaction with the court in order to make this happen. Otherwise, I think they lose steam. And after the disposition, they go off and maybe they run into some problems. And then 6 months later, we're coming into court, and defense counsel are saying, well, they tried to get into the parenting class, and we want to come back every 90 days so we don't have those issues. Because, yes, sir. Yes, we are going to have those issues. And that's one of the reasons we're setting in the courtroom, so that if we have an issue where there's a mandatory, a 6-month review that has to be done, but it's 10 days later than our 90-day or whatever, we'll arrange that in the courtroom so that you're not coming back. We're going to make it so that you're not coming back over and over and over. Yeah. So no, exactly. And these are our dates that we're doing just to try to keep these cases moving forward and being effective. So by all means, in the courtroom, if we don't catch it, say it. Well, we're supposed to have a review like in 10 days. Can we just do? Yeah, we can do that. So we're going to be setting in the courtroom. So it's not like we can't just change it. Right. Exactly. Some of them are going to. Exactly. Does that make sense? Okay. We will set at the disposition, we'll set our 90-day review. We will set our annual review date, and also the dispositional journal entry will indicate the sunset date. So that, yes. Yes, that's why we're doing it in the courtroom. So that oh yeah, so good point, Neil. Thank you. Make sure you bring your calendars with you. Hopefully not everybody's still using paper calendars, and we're actually have it on our iPads or phones or some technological device. Bring your calendar, because we don't know when you're on vacation. We don't know other things. So we're going to have the ability to look at it right in the courtroom. And you can decide what, if it works for you or not. No, we eventually, so again, as I said, until we are done with these private custody cases, we're jammed and we're doing the best we can. But when those are gone, we have 5 days a week we can do this. So we did talk with both Miss Adkins and Miss Maxwell, and they're like, we work full time, so we can be here whenever. So we're willing, you know, we can do that. So we'll have a lot more flexibility come next July. Does that answer your question? Okay.
You mean this July?
No, July of 23. So we're starting our new procedure this July 1st of 2022. But we're gradually working into it, going fully into effect next July, because that's when our private custody cases are gone. So we're still going to do the 90-day reviews. We're going to get it in. We're going to make it work. It's going to be a struggle frankly, for us more than you guys for the next year. It's going to be a bigger struggle for us. But like the entries, we're not totally ready on our entries for July 1st. But we're getting there. And so you'll still see some checkbox entries, but eventually you're going to start seeing more thorough entries, and then you'll understand where it's coming from. All right. Alex, again, so at any point in a case where we feel that the case manager might be able to help, what our goal is number one, the reason we have CASA is because our volunteers for CASA are making sure that we don't want to see these kids moved 500 times. And JFS, no offense, I know Julia's sitting back there and I don't mean to diss JFS, but JFS, you know, has issues, and they will place a kid and they'll move the kid 5 days later, and then the kid gets moved again. And we're trying to avoid that. I mean, we all know how traumatic that is for children. I mean, it's horrible. JFS is supposed to notify us within 24 hours. That has not been happening. That is going to happen because we have to know with the court, it's a statute. You have to do it. It's not like you get to pick and choose, right? So they have to notify us within 24 hours. That's one of the things our CASAs are really keeping track of, is that these kids are not being moved as often as they are. I get it. Sometimes they have to place somebody the first day because it's in the middle of the night, and then they have to move them at first for whatever reason. But part of what our CASAs and GALs and our case manager are here for is to try to resolve some of the problems that force JFS to move these kids. Some of these problems can be resolved. Sometimes they're super simple reasons that we could fix it and you wouldn't have to move the child. And Anne, I think you told me about one. It was really interesting and it was resolved and the child didn't have to be moved. And I can't remember what the reason was. It was really simple. Something you guys, and you're blanking. So yeah, I can't give you that example. So at any point we may, and feel free as attorneys to request that we ask Alex to be joined on, you know, to be assigned to the case. We're happy to utilize her, what she has. We're hoping to get another case manager as well. We may have 2 next year. So that could be another option. So it would give you guys extra people to utilize if necessary. Did you want to talk more about case manager?
So I will be also being on top of JFS for the case plans and SARs. So the magistrates and the judge can actually read the SARs instead of the day up. So I will.
Instead of as I'm walking into the courtroom.
So I will be talking to the workers as well when the cases come up. I will be kind of trying to get them. I'm wanting a week, but let's start off with a few days prior to the court hearing. Because as you all know, I was with JFS and you can get it done plenty of days before the court hearing. So we want all of, you know, the attorneys as well to be able to read the SARs, the 90-day reviews. So just to give you guys enough time to get those as well. So I'm here to help, you know, everybody out. And I've actually already been assigned to a few JFS cases as it is. So I'm talking to the CASAs, the guardian ad litems, you know, even the attorneys, trying to help them out in any way I can. With all the resources I know, I can, you know, try to get stuff done within that week. I've talked to Kristen as well as Julia. They've asked me to do a few things, so I have actually done stuff for them as well. So I'm kind of the jack of all trades with everything right now. So whatever you guys need, feel free to, you know, ask the magistrates or the judge to add me on the case, and I'll try to see what I can do to help you guys.
I think we are also, and somebody feel free to jump in here if I say it wrong, but I'm pretty sure we're starting a drug testing beta kind of program where we can actually order drug testing right from the courtroom and they can be tested right here in the court. So that if there's always those issues, right, where one party, JFS says, I don't, we tested and your client's like, I didn't test positive. It's not true, or they didn't do this, or they didn't do that. Well, the court is starting a drug testing program that we can do here. And I don't have all the information because I've been kept out of the loop on that one. So we may be able to offer that service as well. You don't have to do it, but you certainly can ask to do it. If it becomes an issue, the court can always order it. So we have the right to do that. And we may order the drug testing right here just to get our answer so that we know whether that's an issue. Because again, ultimately, child safety is our concern. So we need to make sure that people are doing what they're supposed to do and we can reunify people in a safe manner. So anything more on that?
We are looking into also, I have been doing mediations for JFS. I've been sending the referrals over as well. Also, we do have that parenting class for the private custody cases, but JFS is actually looking to be referring some of their clients to that program as well. It's 3 classes, just a month, and it's actually very intense. And a lot of parents have actually asked for more classes. So that's eventually what we're going to work on with JFS is some clients, may only need a few classes, and I will look over those referrals and see if they fit our parenting classes.
So right now, the JFS, I think the JFS plan is they have these 12-week classes and it's very difficult to get into them and they're really long and people have a hard time. So we have a more condensed version for the less involved cases that don't need a 12-week co-parenting class. So we can also do that through our parenting class, and we're working with JFS. So that's not, we have not finalized that yet. They want to come and see our class and make sure that it fits their qualifications before they agree to continue to want to work with us on that. So we don't have answers on that yet. So we're working on it. Anything else, Alex?
No,
All right. All right. So there is the quality hearing. Thank you. Toolkit guide from the Supreme Court. Please feel free to go there and see how we're going to plan on doing our quality hearings so that you aren't taken by surprise as we're doing it. You guys have already seen some of it because we've been doing it a little bit more and more. I just want to take full responsibility for why no one's allowed in the clerk's office except for the clerks. It's not them, it's us. Just so you know, I can't have people going, I can't have attorneys running in and out of our clerk's office. I used to do it as an attorney. I loved going in there and talking to people. And I did it in my probate court too. And then I became judge and I realized, oh my God, we're like really distracting. And I never saw it that way. I was very selfish and I just liked talking to the people and having fun and chatting with them and being their friend. And then I didn't realize that I'm only one of 15 people who are all going in there and distracting them. And so we made the rule, no one in the clerk's office other than the clerks. If you need something, you got to come to the window. I know we have those mailboxes back there. Those mailboxes, you just come to the window, they will get you your paperwork. Eventually, we are going to have all e-notification. We are in the process. We're like this close. If you haven't signed up for e-notices, we will be doing all of your court notices can be done e-notification. So you don't have to come and pick it up here. I think we're the only court in Portage. I don't think the other courts are doing e-notices.
Yeah,
they are?
Yeah.
So we're finally catching up to them. Okay, well, all right, we're doing e-notices. So anyway.
You're the first to do a notice to a party, so we're playing with that right now. Using CASA as our party because they're a party on a lot of cases.
Okay.
So we're kind of testing
Some of that. So yeah, so don't be mad at the clerks about not allowed in there. I apologize, but it's really, everyone in there is new. And they're all learning new jobs, and we're doing all cross training. It's not going to be one clerk only does this and one clerk only does that. So they're doing all their cross training, and it's really hard. And so every time we walk in there, and I don't want you to think you can't talk to them, go get them. Just go to the window and say, I'm gonna use you, Rebecca. I'm sorry. I'm not calling you out by any means, but I know you have that cute little baby that we all love to see pictures of. I don't want you not to be able to show them pictures of your baby. So go to the window and say, hey, and or go around, but I can't have people going in there. And and try to keep in mind that you're one of 15 people. So if 15 people go in there and each spend 5 minutes, I can't do the math, but I'm sure some of you can. I cannot do the math. That's why I became a lawyer originally. So that's on us. I'm trying to think, was there anything else? Because I know Anne wants to, I think Anne is quickly gonna, you didn't know this?
I did not use her hand once.
Oh, no, Anne does not want to do this.
Okay.
Anne does not want to do this, but she's going to come up and talk a little bit about CASA. She's going to do a quick thing so that everybody understands what this program is and how it all works. And I'm going to give her the microphone. Does anybody have any questions about what we've talked? Garrett. Because we entirely lose jurisdiction as of July 1st, 2023. So actions all will be in domestic. I know, yes, that's exactly what it is. So we're working with Judge Gilletto on how to do this, because somebody is gonna file June 1st, right? And so I think what we're gonna do is schedule the first pre-trial or whatever. I don't know how the private custody timelines go, but we're gonna be checking with them, and then we're gonna come up with all kinds of notifications to the people to let them know where they need to be after July 1st, so that they can actually know what's happening.
Free trials here, and then there's.
Yes.
I think they should give. Domestic relations jurisdiction before they take it away.
I would agree, and I will tell you honestly, like, I've never done this before, so we wrote this legislation and we took it from other counties because we didn't even know. So I don't think other counties did what you're suggesting, which would make a ton of sense. But we're just gonna have to try to figure it out. We're gonna spend the next year figuring it out. So, but unfortunately, that jurisdiction ends July 1st. Okay. So, yes.
Your Honor, you said for one of the councils, they make too much money or they want to go private counsel, then they won't have an attorney for them at the state.
Correct.
But otherwise, there will be an attorney for.
Absolutely. Every other year, they will have.
Oh.
Absolutely. Anything else?
Question. on
Yes,
the statute, changing the court jurisdiction.
Yes.
Is that statute only for Portage County?
Yes.
Okay.
So how they do it is each county, there's 10 other counties who have done this. So I think we're 11. So there's 11 counties now who have transferred their, I call them unmarried divorces. They're unmarried divorces to domestic relations. There will be the 11th county. So it's individual county, but it's still in the statute because this.
Seems like a good idea, and you think
I think it's a great idea, and they're trying,
uniform.
so what they're trying to do is, we were talking about it down in Columbus, is they're trying to come up with a way for any county who wants to do this to avoid having to do what we did, which is put this bill through and all this nightmare that we went through. And they're just gonna have a procedure for counties to apply
to change their jurisdiction without having to do a bill for every single county that wants to do this. So of course, we're gonna do that after we went through all this, so. Won't help us, but it'll help other people, I guess. All right, anything else? Is there anything?
No, Jerry, I just kind of want to piggyback the question of how we're going to transition all the
Thanks,
cases.
Neil.
I know that Judge Smith put together a team and Judge Letta's put together a team. And we're meeting monthly between now and July, to try to figure out how to smoothly transition all those cases. So it's not just, somebody loaded all the cases in the truck and driving over on July 1st. I mean, we are trying to figure out a way to get it done to make it as smooth as possible for everybody. So we don't know the answer yet. We're one meeting in.
We're one meeting in,
So-
so, because we weren't gonna waste our time until the bill passed.
Is that this July first?
No.
July 23.
July
July 1st,
23.
23.
Okay.
All right, anything else? All right, I'll let Ann. Ann really wants to talk. so-
All right. I'm sure pretty much everybody in here has heard of CASA at this point. So we started back in September and we're now officially rolling. So I just wanted to kind of give you guys a brief overview of what we're doing, what I'm doing with the CASAs, so you know what I'm training them on and what their expectations are and any questions that you might have. So what they get trained in our training is, the first thing is that they're gathering facts related to that child's past and current situation. So anybody who does GAO work is already doing these things, right? Talking to everybody who has contact with the child or has interactions with them, and then requesting all the records that that child is involved with, whether it's mental health, educational, whatever's going on. They're engaging with the child during regular visits. So they're meeting monthly face-to-face with the child in their home environment so they can assess and make sure that that child's getting everything that they need, that they're comfortable in that environment, and also that the home environment is safe and accommodating for them. And then just maintaining regular communication with everybody involved in that child's life. So parents, caregivers, extended family, schools, anybody who's meeting with that child regularly. Then, of course, we're making recommendations in the best interest of the child. We're training our CASAs how to write reports. And then once those reports are written, they submit them to me for review. So we can kind of talk about those reports if we need to make changes, because of course they're learning. And then we file those reports with the court 7 days before the hearing. I do send those out to everybody who's counsel for the parents through email. So I'm sure some of you have already received emails from me with some reports on it, but you can regularly expect those coming from me. You'll never get an email from the volunteer, but that'll come from me. They are being trained to be objective and neutral on their cases. They're also trained to maintain confidentiality. So we have confidentiality policies and agreements that they sign at the start of every case. And of course, we talk about this extensively during all the training we do with them. So just some of the things that a CASA is not going to do, just so everybody's clear, is that they don't work under the direction of any other professional. So they are independent in their assessments. We're not going to do what anybody else is telling us to do. If that's a mental health professional telling us a kid needs this, we want this to happen, or JFS saying this is what's going to happen, we're going to compile that information, of course, and present it all to the court, but we're not taking direction from any other professionals. CASAs are never going to provide childcare, placement, or transportation for any of the kids that we work with. So you're never going to see a CASA going to a foster home and picking up a kid and taking them to McDonald's and talking with them. They don't give gifts either. So you're never going to see a CASA come and give a present to a child, anything like that. So we go through all of that in our training with them. They're also not acting as a mentor for the child. We talk to them extensively about what their role is in managing and reporting on the best interests of the child. They're also not attempting to prove anybody's guilt or innocent and not deciding what happens in the case, because that's the jurist's responsibility. So how we assign CASAs here is, the first step is the judge or magistrate makes that initial decision out of that Rule 6 hearing. So once that determination gets made, I get a phone call from the clerks or a notification that I need to pick a CASA to be assigned to that case. So I get a copy of that information. I kind of do as much as I can, a little bit of background screening on that case to see which CASA would be a good fit for it. And sometimes cases just work out. And for example, Tom is on a case with one of our CASAs, and there are allegations of a child having a bleeding disorder. And no joke, this CASA for a living trains parents how to deal with kids who have bleeding sores. So it's like just a, wild coincidence, but I do try to fit CASAs well with families. I want to try to make them match with families well and make them match with children well. So like I said here, so for example, we have CASAs who are retired teachers, retired intervention specialists, retired medical professionals. So if I have a case where a child's been having a huge struggle in school, I might choose one of those retired teachers or retired intervention specialists because that background could really help that child in the long run. So those are the type of things I'm looking for when I'm assigning a CASA volunteer. So then that CASA gets all the information on the case. I talk with them and see if they're comfortable taking it, making sure there's no conflicts of interest. Of course, we review all of that to make sure there's no personal financial relationships between the CASAs and the family involved. If there was a conflict, I would move on to the next CASA and pick somebody else for that case. So that's kind of just the process of how I choose CASAs for cases. Then for the training, so our CASAs go through 30 hours of pre-service training. So before they ever get a case, they go through 30 hours, it's a national curriculum. So National CASA provides this to us, and then we train our CASAs on that. And it goes over a variety of topics and information like mental health issues, substance abuse, domestic violence. I think you can name it. Any issue that you might stumble upon in our cases, we touch on it during our CASA training. And then after that, they get 12 hours of annual in-service training. So that is provided by our office. I have a different training selection provided every month by a different training provider. They are also welcome to go out and get their own training. So if they see an interesting training that somebody else is providing, they can report that back to me. And then of course, I'm there to supervise all of the CASAs. So I'm regularly checking in with them. Sometimes I'm going out with them on home visits, helping them with records, anything that they need along the way, I'm there to help them with. So if you wanted to have some more questions about the CASA model or just in general, I always suggest the National CASA website, which is the first one up there. It just goes into really good detail about what the CASA model is and how long it's been in effect. And exactly what National CASA's model is what we're following here. And we do have national membership. So we're going to continue to adhere to all of those standards. Any questions about CASA?
Questions about anything? Eric, you raised your hand.
Yeah, I'm gonna read those resources before asking more questions.
You sure?
If you put them up there, I'm gonna read them.
All right. All right. So, thank you guys. Does anybody have any